All right, we are back. Elizabeth still looks like a biker, but I do not. I took my jacket off.
Bikers good. Harleys are good.
Yeah, even though it's a little chilly in here. So in this little episode, we're going to hop into a little more specifics about creditor rights, creditor protection, and some of the change that Elizabeth has been fundamental throughout her career in trying to implement. On one side, the last podcast, we kind of talked about her career, a little bit about her background, some of the things she's been doing. A lot of that's on her website. Well, it's on her CV, which is on the website. You can go check it out. She's been in, a billion articles. I can't even count them all.
Yeah.
And you've helped write or draft, I should say, parts of the IRC, the Internal Revenue Code. Wrote a textbook. But one of the things that we wanted to talk about specifically on this one was the idea of creditor rights, and specifically in the context of charging order protections for LLCs and LPs, and what a charging order is and why it's unique as a creditor remedy and why it's something that we prefer from the asset protection side. So why don't you go ahead and establish the idea of what creditor rights are, what they mean, and how are they limited, and how are they different in the American jurisdiction?
Good. Okay. Fantastic. So when you are, if you think about kind of the intersection of capital and debt, right, at that juncture, the question is who has rights to what, right? So I have money, I invest it in a business. I, in some respects, am kind of a creditor. Like, what rights do I get in that business? Versus what if I borrow money? What if I borrow money from you? What rights do you have to get that money back? So the big picture is rights vis-a-vis I've got the money, you owe the money, and what rights do you have, right? So to give, because I always like to start, I always like history. So let's go back to, at the very beginning. Our legal system is based on the English common law, and the English common law was oral primarily until Queen Elizabeth, who, and of course, I love the story. I mean, goodness gracious, Elizabeth was a woman. She wasn't, she was educated. She was a pretty amazing person, even though you could argue that
the original Miss Independent.
Exactly. Well, the horrible histories has a lot to say about poor Queen Elizabeth. But but one of the things she did was she codified the oral law, which was an incredibly important thing to do. So it was 16th century between 1540 to 1570, and they were called the Statutes of Elizabeth.
Mm. So up to that point, it was just oral law, and it was just common law, but it wasn't codified in any.
It wasn't written down, right? Yeah, it wasn't written down, and if you think about it, prior to Elizabeth too, the Bible was in Latin. Ordinary people didn't understand it. Right. The legal system was completely oral, so nobody there weren't any checks and balances. That she in many respects, I align I feel like she and I have a lot of similar ideas and views. I want things to be clear. I know, really. Yeah. And besides the fact that she perhaps killed people, which I hope is not part of my tradition. But,
And she was shorter in stature as well.
Was she shorter?
Yeah.
Than me? How is that possible?
She's like 4'10". She's tiny.
Really?
Yes.
Oh my gosh. Okay, well.
So was Victoria.
I had no idea about that. So she codified the laws, which made it so much easier than for people to know, you can't pull the wool over my eyes, this is really what it is. One of those statutes was called the Fraudulent Transfer Statute, and it codified the English view of these rights, these creditor rights. And the idea was that, and you think about it, it's an agricultural environment. It's not really as sophisticated as today, right. But there were maritime activities back then, and so there, some of this grew up too out of admiralty and maritime, trade and finance. And the question is, if I loan you money, right, and you don't pay me, what are my rights, right? And so let's start with a cow. So I know you have a cow, so I loan you money, and I figure I'll get the cow, right? You have some assets. If you don't pay me back, I have a right to get the cow. But what if you take that cow and you go hide it in your neighbor's barn? Oh, I don't have that cow anymore, right? What were my rights as a creditor? Well, the fraudulent transfer statute said that if I moved that cow purposely, right, with an intent to defraud you, it's clear. That's avoidable transaction, meaning the neighbor, I have to go and tell the neighbor, sorry, I have to get the cow back. Mm-hmm. That transfer was ineffective because I actually owe the cow to this creditor, mm-hmm. right? So that's really clear. That was an existing creditor, and I did it intentionally. If, on the other hand, I just had to sell the cow because I needed the money, and it wasn't an intentional act to defraud the creditor, then the creditor had rights to the cash that I received. And but if the cash was spent on living, my creditor might be completely unsecured, mm-hmm. right? So that's kind of the big picture. I'm a creditor. What do I have the rights to get? The concepts are existing creditors versus future creditors, and intentional versus unintentional transfers. Mm-hmm. So that's the big picture. So fast forward to our country. We adopted, in really whole cloth primarily, except in states like Louisiana, the English common law. Mm-hmm. So we just bloop, globbed it onto our legal system. And in the fraudulent transfer world, it's even more interesting because we just called it the fraudulent transfer statute, and adopted it, in many respects, whole cloth, exactly the way it was in 1577. And what does that look like and mean? What it means is there's still a lot of gray area.
You're good. Keep going.
Because while there are still the same concepts, are you an existing creditor? Are you a future creditor? And if I'm the debtor,
why that makes a distinction in terms of who can collect first and who can. Why does that distinction matter between existing and future?
So existing creditors are people you owe. Mm. Like I know I owe you money. Mm-hmm. So it's much more intentional.
Right.
If I transfer assets, leaving me without the ability to pay you.
Right.
That's not cool.
Right. So yeah. So a very practical example of what she's talking about she mentioned with the cow. In today's context, it would be if you had an account with $1 million somewhere and you had a creditor that you owed $1 million, but they didn't know about that account, and you took that money and transferred it somewhere else and hid it from them, or tried to move it overseas or something like that. That's a fraudulent transfer.
Absolutely. Yeah. It's done with intent to defraud that creditor. There's a kind of staying with that concept of an existing creditor. The rules have developed, and the concept existed in the Statute of Elizabeth, that as long as you are solvent after a transfer, you are. It is not a fraudulent transfer. And what does that mean? That means I take all of my assets, all of my liabilities, including my contingent liabilities.
Right.
Contingent liabilities are
things you could owe.
Exactly. Things like alimony, child support. If I guaranteed a debt, those are contingent liabilities. So you take assets less all of the existing liabilities and contingent ones, and then what's left over is the amount that you can transfer, which wouldn't be fraudulent vis-a-vis an existing creditor.
Right. So if you're Elon Musk and you owe somebody $30,000, even if he takes $30,000 from some account and moves it somewhere, it's not going to matter because he has plenty of solvency to be able to deal with that debt. So
exactly.
That's what she's referring to, is like you can go through and look at, okay, is it actually a transfer that's going to affect your ability to pay? And that's a determination the court can make.
Exactly. Yeah. Now, the general rule is if I'm making a transfer, Kev, to, I have no creditors today at all.
Congrats.
I know. Isn't that fantastic? Shout out to Dave Ramsey. Shout out to Dave Ramsey. But let's assume that, I have no creditors today, not contingent creditors, whatever, and I make a transfer. Let's say it's kind of huge. It's, it's $1 million. I move $1 million out of my hands into something that's exempt. And we do need to talk about what that would look like. But just in an easy example, let's say that I buy a house for $1 million and it's my homestead, right? Mm-hmm. And it turns out that later somebody sues me and gets a judgment, and they want to argue that that was a fraudulent transfer. I should have known that they were going to pop up. Let's say I'm a lawyer and it's a client, and I should have known, and I don't have the insurance to cover it. Well, the court will probably say, well, A, it's homestead, so it's exempt from the claims of creditors. Mm-hmm. And B, even if it wasn't homestead, I had no reason to expect that there would be that creditor. Therefore, even though there are no assets to pay the claim, they were a future creditor at the time I made the transfer. Right. Therefore, public policy says they don't have a right to get to my assets.
So existing creditor is something you owe somebody money. Future creditor is you didn't even see it coming, and right. Therefore the case for a fraudulent transfer is a lot weaker.
Exactly, yeah. Exactly. And if you think about it, again, from a public policy standpoint, that really makes sense.
Yeah.
Who are we trying to protect? Mm-hmm. We want to protect people who have a reasonable expectation of getting their money back. What's interesting when you start talking about the specifics of asset protection and legislation, et cetera, banks and other people who lend money in the secured credit world, they're really comfortable with that concept. Mm-hmm. They understand that they have to look at a balance sheet and they'll make a decision about whether they think you have enough solvency to loan against, and they'll make that decision based on the numbers. And if later those numbers don't exist, they understand it. They accept it. Banks get it, right? Mm-hmm. Which is why they have you update your balance sheet and all of those things.
This is why when you go get a mortgage, they check everything.
Right.
What do you own? Do you have any juicy IRAs we can get a hold of? Do you have a firstborn child? Well,
right.
not always.
Not exactly.
But the point is the bank wants personal security, and just to establish that concept, security means they're able to go get something if you don't pay back.
Right.
Just like with the cow example.
Exactly.
And unsecured means they don't have any recourse. They're just trusting you.
Right. Exactly. So if you think about the concept of secured versus unsecured, secured is when you buy a house and they get that lien on your house. Right. They're secured creditors. Unsecured creditors are, let's say you have a line of credit, and it's not an equity line of credit, you just have a line of credit. Or you have a credit card. That's an unsecured debt, right? So if we take the public policy argument a little bit further, secured creditors are first in line, because they've established a lien based on statute and consent. Mm-hmm. I've consented to that lien, right? And so I'm going to be personally responsible, and everyone knows that if I default, we know the rights and obligations of the creditor and the debtor. It's very clear. Where you have a problem, and one of the things that's happened in our system when we're looking at these issues, our legal system has developed in such a way that and this is something that I don't know that we're ready to talk about right this second, but it encourages litigation. So when you start thinking about some of the things we're getting ready to talk about, what a charging order is and how it works, et cetera, the challenge is that plaintiffs' lawyers in our country can take a contingent fee, and so they're encouraged to sue people. Now, I'm not saying all plaintiffs' lawyers are bad. They serve an amazing purpose. They take care of, and our system that is.
Shout out to all my buddies in California that are plaintiffs' lawyers.
Exactly. Yeah, the good guys. They're
the few good ones.
The few good ones. But when we start to really talk about that, we will again be talking about the difference between our country and other westernized countries. The purpose of allowing a contingent fee, which most countries don't allow, is to give the ability for people who don't have money, people with no means, to have access to the court system. So it was an amazingly important thing to include. But the challenge is now that it's a whole business model.
Yeah.
So our public policy actually, it's interesting because we favor, and this is historical, we favor contractual arrangements whereby an individual with full knowledge and understanding gives a lien to a creditor and then accepts the consequences of that lien if they don't fulfill their part of the bargain. That's what we prefer. But there's this whole other group of creditors driven by a judicial system that has built into it currently a desire or a process that will encourage individuals to bring lawsuits, because if a plaintiff's lawyer can find a class of people who look vulnerable and then go to them and market their services and say, I'll take 50% of what I get for you, just sign your name, then they go get the money and they get 50% of the proceeds in a class action suit. It's created an environment where then they become judgment creditors, and they don't get the same protection as a secured creditor.
Yes, which has a frigid effect on lending, because the more litigation that's out there, the less people are going to be interested in starting businesses and doing everything else. So, so in... did you finish what you were going to say?
No. So taking that background, now the question is, you have a secured creditor and you have an unsecured creditor, right? Secured, it's very easy. You have a lien, you collect on it, and while if there's competing interests in secured creditors, which there can be, you may have to work that out, but generally that's pretty clear.
Right.
Now what we're talking about are unsecured creditors, which are primarily judgment debtors.
Right.
They can be spouses, individuals who don't have a secured interest in a particular asset. Now the question is, what happens? What happens when you get a judgment? So the answer is step 1, lawsuit. Step 2, judgment. Step 3, discovery, post-judgment discovery. Step 4, now collection. So how does collection happen?
And this is so important because a lot of people think that once you get a judgment, that's it. Oh, the court gave me this much. The court did this much. I mean, what's happening we see right now with the Alex Jones lawsuit, it's like you can give a judgment for $1 billion.
Right.
If he doesn't have it, it doesn't matter.
Right.
You can say whatever you want, and that's kind of a different thing because it's all punitive and very performative. And it's but what Elizabeth's talking about is like there's a process of collections where you have to find out what somebody has and go get it.
Right.
And that's not a very easy process. It could involve using the police, and the court has some authority that they can use. But that's a whole process in and of itself. Just because you got a judgment, it doesn't mean that you're just going to get that money in a pile of cash somewhere immediately.
Right.
There's this whole process you have to go through. So anyway, so collections.
So now we're thinking about collections.
Right.
So the question is, what can you collect? So the easy thing to do, you take that judgment, right, and you file it in the counties where there's real estate. Now, if there's homestead, the owner of that homestead will win. You cannot force that house to be sold. And again, some states have more protection than others, and we can talk about that, but this is just the general concept. Homestead, they can file, but they're not going to get anything because once they file, now they are asking the court to force a sale of the asset and give the proceeds to the creditor, right? If, however, you have other real estate, investment real estate that isn't protected by homestead, then they file the lien and they ask the court to judicially foreclose on that lien, sell it on the courthouse steps, and give the creditor the money. So that's one collection thing to do. Another is garnishment of bank accounts. They'll go and they'll locate all of your bank accounts, and they'll go to the bank and say, I have this judgment. Bank, you need to turn over these assets in satisfaction of the judgment. You can see that that's the banks are going to be concerned because how are they going to coordinate?
Right.
And because they have an obligation to their account holder, there is litigation that ensues.
Right.
It doesn't just happen automatically. Now,
This is why what happened in Canada recently was such a big deal, because they had a government and banks unilaterally just taking those funds with very little investigation of what was actually going on.
right.
So yeah, you're right. There's that's why typically there's a litigation process where it's like the bank's like, no, we're not just going to give you something because you're a creditor. We actually have to see some proof.
Right, but when you have a governmental entity, then again they will sidestep those those protections,
Right.
And going back to our earlier constitutional discussions, that's one of the problems with having centralized government, because they can overreach.
Mm-hmm.
So again, everything is cost benefit. We need to protect. We have to have protections built into the system, and what happens so often is people get afraid, and then they say, oh yeah, okay, it's fine, give up all those protections. Yeah, that's right. What they were doing was really bad. Take their money, without realizing the precedent that sets.
It's you next.
I know, it's you next. Exactly.
Yeah.
What is that old saying? Well, anyway, it was fine when it was the person down the street, and then it was your neighbor, but then they come for you,
Yeah.
right?
Yeah.
So that's kind of generally what you're looking at when you're looking at entity structures or trusts. Now it's a different matrix.
Mm-hmm.
So when you have business entities, you have different types of entities and different remedies. And maybe it's a good time to tell the audience, when you're thinking about what a creditor can get, you don't just look at the statute, the governing statute about an entity structure, because that's just how does the entity work, who has
Right.
rights, et cetera. What you also have to look at is something called the Civil Practice and Remedies Codes, because those are where the courts get their authority to establish a remedy for a creditor.
Mm-hmm.
So,
Which varies by state. It's more of a local.
it does.
Right.
It varies by state, but with regard to the certain types of creditor remedies that we're going to talk about, it's pretty uniform.
Mm-hmm.
So before we talk about that, it's really important for everybody to understand what an entity is and what it looks like, and the various types of entities and how it differs from a trust, I think.
Mm-hmm.
Because when we are thinking about a charge, what rights a creditor has to your interest in an entity, you have to understand what that entity looks like. So let's talk about that, because all limited liability entities limit the liability of the owners from business liability, right? So whether it's a C corp, and whether it's a per se corp, I'm going to call it a per se corporation, whether it is on the other end of the spectrum, a general partnership or joint venture, and in between, a limited partnership or a limited liability company, all of those entities will protect the owners from business liability as long as the corporate formalities are followed. It's treated like an actual corporation or company, et cetera.
Mm-hmm.
So that's consistent,
Mm-hmm.
right? What isn't consistent is the rights that a third-party creditor would have to a debtor's interest in those entities. So, and here's why. If I have a corporation is an avatar. You can make it look like anything you want. You can have glasses, dark hair, blonde hair. It could be short, fat. It could have, blue lips, pink lips, whatever you want it to look like. So in the corporate world, that means what's the governing law, how are shares transferred, you can.
That was a metaphor, if you guys missed it.
Yeah. You can do anything you want with this avatar.
Mm-hmm.
What I own then is a share in an avatar,
Mm-hmm.
and that share in that avatar is easily transferable because it's not going to affect what happens to the other shareholders because they still own part of the avatar. Now there's just another shareholder. So it's very, very easy for a court to say, okay, Mr. Debtor, turn over your shares to the creditor, and it's not going to disturb any of the other owners. So the remedy against a corporation is a turnover order.
Right.
Okay, so that's pretty easy. On the other end of the spectrum is a general partnership. You and I decide that we are going to invest in a pig farm because, pigs are cute and, we don't want to do it alone. We want to have someone else to muck about in the mud with us. So we have a pig farm. As opposed to the avatar, which is we own a share in a thing. Mm-hmm. If we are joint venturers and general partners in a pig farm, each of us owns an undivided interest in every one of those little pigs. Mm-hmm. The little curly tail, the spotted little body, and the little pink snout. Each of us has an undivided, you can't divide it. You can't cut that pig into pieces. So if, Kev, you go and, do something risky, which you never would do, but let's say you did, and you had a creditor.
Gambling debt,
exactly. Who showed up and said, okay, court, I want Kevin's interest in this venture. If the court allowed them to collect, it would harm me. Mm-hmm. Because you and I, and now the creditor and I, have an undivided interest in each of those pigs, and that's not fair to me, right?
If you're trying to run a pig farm,
some
stranger comes in that doesn't know what he's doing.
Well, it's not even that, because he doesn't want to run the pig farm.
Right.
He wants half of each pig.
Right.
So, and you can't really divide up the pigs. He'll want all of the really good pigs, mm-hmm. and he'll want to leave me with the pigs, the real pigs, right? So, so that's really the problem. He's not interested in running the pig farm. He wants your interest in each of those pigs. So what the court came up with historically was, because that's called an aggregate ownership regime, mm-hmm. as opposed to an entity regime, which is a corp. The court said, yeah, that's not fair. Mm-hmm. That's not fair to your other joint ventures.
So it could ruin a small business. I mean, it could totally destroy the other partner who's innocent and has nothing to do with your gambling debts, but all of a sudden they can't even run their pig farm anymore because this creditor came in and took everything.
Exactly.
Right. So that's what you mean by third-party creditor. It's somebody that's outside of that partnership relationship that's coming in and trying to steal the value from the partnership.
Exactly. So the civil practice and remedies codes were developed mm-hmm. In such a way as to say, okay, you can have a charging order only. In other words, no turnover mm-hmm. of the undivided interest in the pig farm. Instead, you get an order that sits there, and every time the pig farm pays money, it goes half to the individual owner who's not the debtor and half to the creditor until the creditor's rights are satisfied. Right. That's a charging order.
Right. So, and a charging order is better from the perspective of the partnership because, well, it's not very attractive from the perspective of the creditor because you can't control when those distributions are even made.
Exactly. Which led many people to suggest that you need to form, if we're thinking about asset protection, we want to form entities that aren't attractive to creditors, mm-hmm. kind of the poison pill idea. So let's leave that on the table for a second. Here's a charging order with regard to a general partnership. In the middle, you have now limited partnerships, which developed after general partnerships. The idea that you'll have some people who'll be generally liable, and that's the general partner,
right.
and then other people who are limited partners and have limited liability, which, just a little cute historical point of fact, it was really the Catholic or Anglican Church that drove a lot of that because they had all this capital that they wanted to invest.
Really?
Yeah, if you look at it historically, we could probably do a whole thing on that.
So the church wanted all the capital without any of the risk, basically.
Exactly.
So they wanted to be a limited partner or anything.
Exactly, and
can't sue God, can you?
And the individuals who agreed to that to be generally liable, they were fine with it because they just needed a way to get infusions of capital. And the church, back in the 14th, 15th, 16th century, was who had all the money.
Right.
But in any event, limited partnerships came later, and they too were aggregate ownership regimes in that everyone owned an undivided interest. The difference was just liability. general partner would be generally liable for the business debts. Limited partners weren't.
Mm-hmm.
And then limited liability companies were developed much later in the 80s. And limited liability companies, interestingly, were developed by oil companies because they wanted something that looked like a partnership for certain purposes and looked like a corporation for other purposes.
Right.
So the question then was, what applies? Because the limited liability company statutes were based on the partnership statutes, they then were put in the aggregate ownership regime bucket, right? Now, so charging orders applied to all of those, general partnerships, limited partnerships, and LLCs. But what's interesting is two things. First of all, across the board, the statutes changed to say that those aggregate ownership regimes were actually entities. And nobody ever really talks about that, because if they are entities, then a charging order shouldn't apply, right? If there's protections for those other partners, then the charging order shouldn't apply. But something kind of unique happened in this world, and that is that I was working back when I was a young lawyer, 80s, early 90s. All of the lawyers just walked around chanting a mantra. A charging order is the exclusive remedy against a partnership, and then they would bow and then hit the dong or
Literally.
the gong. Literally.
It was a religious cult.
It was a religious cult. And as a young lawyer, I was hearing this from the planning bar, but I had worked for a really amazing divorce lawyer in Houston. I clerked for him when I was in law school, and I was watching him. He didn't say a charging order was the exclusive remedy. In a divorce, they just busted up those partnerships, And I started wondering, how were they doing it? And I went and I looked, it makes perfect sense. A charging order creates a lien on the partnership interest. And if you can show bad faith, then a court will allow you to foreclose on that lien and bust up the partnership. So a charging order was not the exclusive remedy against a partnership. So I wrote an article. Do you know what year that was? It was in
I was trying to figure out if you're talking about this one.
Well, that was when it was included in that book. But I think it was originally published in 98. And you would have thought that I said that the world was flat. Nothing against flat earthers, but you would have thought that I was saying that the world was flat. I can't even explain to you. It was kind of the beginning of the internet. We had people, calling, sending us emails, and in fact, I gave a speech.
People were angry with you about it.
They were angry because if you think about it, there are these sacred cows.
Yep.
And by saying it wasn't an exclusive remedy, basically what I was saying was, you guys you've screwed up,
Yep.
right? And the only reason I was looking at it was I wanted to know substantively what was correct. Is that if we do that, is it completely protected? If I have a doctor who's worried about, he doesn't have enough malpractice insurance, and I tell him that a charging order is the exclusive remedy, am I giving him false hope? Or do I need to look at other options? Do I need to go offshore? Do I need to, what do I need to do to protect his interests? And again, audience, not against creditors that he knows about or should know about, but really this group of people who might target him or her just because of the fact that they have wealth.
And really quickly, where the rubber meets the road here is, if you're running a business and a third-party creditor is able to come in and break up the business and foreclose on it, no more business.
Right.
It's done. Like you're going to have to. It's not going to be able to function as a regular business. But if they come and all they can get is a charging order,
right,
then all they have a right to is distributions that are coming out of the company, which is a lot easier to manage. Someone can still come in and buy the business and take the assets somewhere else and pay off the creditor, et cetera, and leave it. But if there's foreclosure, that destroys the whole business.
It does.
So it's a business-friendly posture to have charging order protection only.
Exactly.
Because it allows businesses to function without having a divorce or some other third-party creditor break up and destroy the entire business.
Which is such an important point because some of the things that Kevin, you've said, when people think about what it is we do, they assume that we're doing it out of bad faith to protect these wealthy people who are doing really terrible things. But first of all, we would never take someone like that as a client, A. But B, what we're really trying to do is protect the ability of businesses to continue to function in a healthy way, despite what is going on with our judicial system that may or may not be allowing excess judgments to occur, right? So we believe it's a really important and healthy way to protect our businesses. And the other thing too is it'll force a settlement. Honestly, if you think about a fair market value situation, if you have somebody with a crazy judgment, let's take, oh, you owe me $2 billion. Oh yeah, right. How are we going to get this to settle? Because again, that's a huge amount of wasted time.
It's essentially an opening offer is what it is.
Exactly.
Sure,
yeah. And again, we're not making a comment about whether we think Alex Jones owes that money or any of those kinds of things. We're just commenting on it because
comment whether or not he could pay.
Right.
But,
it's just a question of exactly can he pay? So I read that article in '98. Oh, I was getting ready to tell you, I gave a speech to a group of lawyers, and there are always speakers dinners at these things, and usually there's some wine and alcohol that goes along with that. And I was in the lobby of the hotel talking to some other speakers, and one really pretty academic gentleman who I had a lot of respect for. I guess I'd had a little bit too much to drink, and he literally accosted me in the lobby and said, "Who are you to say that a charging order is not the exclusive remedy against these partnerships?" And my only answer was, I guess I'm that, little girl in Austin, Texas who just reads. Like, I think that, and the point is that often what the audience needs to know, a lot of times lawyers are lazy. Mm-hmm. We're not going to go and look for something if somebody's not paying us to do it. And a lot of times we do that. We just say what everyone says, It's
easier to just call somebody or talk to somebody and be like, well, this is what we've always said. Charging order is the exclusive remedy. Ding, ding, ding. And it just doesn't always work that way practically.
So then, and part of my reason in writing that article was I started seeing rumblings in the Uniform Act to codify the fact that it does create a lien, and the lien can be foreclosed on. So it was really important. Once I started, I realized that that's what it did, then all of a sudden I saw rumblings about that. And then same thing happened with the limited liability company situation. And I wrote another article about limited liability companies and charging orders. And it's been really gratifying. You think nothing you do means anything, or, you write things and no one cares. Well, for years, I was giving speeches really about this and foreign trusts. And it was so gratifying, the number of people who'd come up to me and say, oh my gosh, we are changing that statute in our legislature because we realize how important it is to protect small business. And we had no idea that it created a lien and the lien could be foreclosed on. And in fact, the Uniform Act for limited liability companies said that not only could the lien be foreclosed on, but if there's a showing of not even bad faith, but that the charging order hasn't been effective to give the creditor what they need, then the court could actually bust up the company. Could order its liquidation,
Sell the assets.
And so then that was in the Uniform Act, and some states passed it, like Illinois just passed it whole cloth. And so then there were a couple of years where I was out really talking about this, and then the Uniform Act changed to take that particular provision out because it became really clear. So I'm really not tooting my own horn. I'm just saying that it's been really gratifying, but it's been really gratifying to see how discussion of these things can bring about change, which is part of the reason why we're doing this podcast, is to start talking about some of these things in a broader audience, because some of these things are beneficial, at least from our standpoint, because small businesses are under so much pressure from a tax standpoint and a regulatory standpoint that anything we can do to give them breathing room
is helpful.
Is very helpful.
Yeah, and so the way this is played out, generally speaking, now, is each state has kind of adopted a different posture. For LLCs, for example, each state has a different statute for what the exclusive remedy is. If they want to make a charging order the exclusive remedy, often they'll use that language and they'll
Right.
just stick it right in the statute and say a charging order is the exclusive remedy. Other states like California or mostly the bigger, more liberal states have a tendency to not like that. And
Right.
so they usually say it's not the exclusive remedy. There's also liens and foreclosures. Some states have made a distinction between single member LLCs and in the context of LLCs, between single member LLCs and LLCs that have more than one member. And they made a distinction where you can get a lien on a single member LLC, but if there's more than one member, then charging remedy is the exclusive order. So states have kind of played with how they implement this, but generally speaking, more pro-business states have a tendency to adopt the charging order
Right.
as the exclusive
Right.
remedy language because they understand that there's a direct relationship between small businesses operating and the protections that they have from creditors.
And the thing that is really important for everyone to understand is, well, I'm about to make a political statement. There are different communities. Originally states, the majority of rights were ceded to the state. It was really after the Civil War.
10th Amendment, yeah.
Yeah, where the federal government stepped in and said, because of the risk of slavery, we're going to take this away from states. And again, we could have a whole series of podcasts on all the times where we feel afraid of things and then we give up rights, and then we can't really get them back. It's really incredible, the difference between states. You see it in the exemption statutes. What do they exempt, right? So very pro-business states like Texas and Florida, they have very strong exemption statutes, unlimited homestead, things that might look egregious to people, but the reality is that it allows business owners to continue to operate. If you look at states that aren't as pro-business, California and New York are two really good examples. They have very limited exemption statutes. It exempts only a small amount of cash value of life insurance. Your homestead is very, very limited. It's and the the argument for that is more and more some strange kind of socialist economic view that we should, we should all be the same, and it's this kind of communal way of looking at things, which in a utopia, and maybe if it were a true utopia and humans were perfect, would be beautiful and wonderful, and we would all be behind that. But the thing about it is that humans are not. I mean, at least, I believe that humans aren't naturally kind and loving to each other.
Natural utilitarian.
Right. But the point of that really is that states right now have the ability to have their own statutes and to make their own decisions and to encourage business in whatever way that they think makes sense.
Yeah.
And so when you're looking at these various jurisdictions and trying to figure out where you want to operate and where the entities should sit, et cetera, there's a wide choice, a very, very, very broad set of rules and you can choose which state you want to go to.
Yeah, and that really makes a huge difference. A lot of people, the proof is in the pudding with regards to where, like, for example, Delaware is a jurisdiction we love.
Right.
Delaware has
Yeah.
Basically, every major corporation is incorporated in Delaware.
That's
Do they
right.
have their headquarters there? No. A lot of times they're in California or Texas or some big state or big city, but they're still incorporated in Delaware because the laws make a huge difference. The enforcement of the laws, the predictability of the laws. Delaware has a chancery court system that's unparalleled.
Right.
And corporations love that kind of security, not just corporations, but LLCs, business owners in general. You can make an LLC in Delaware and not live there. All you need is a registered agent. And so that makes a huge difference. And so a lot of these companies, different jurisdictions become hotspots for people making. Wyoming is a hotspot right now because it's so cheap to make one.
Right.
And they have charging order protection. So the way states do things makes a huge difference in the way, both in the cost and in the way that you're protected, your assets are protected within the company. So that's, from our perspective, that's a huge deal when we're coaching clients on where to start a business, where to move a business or convert it or whatever. We have certain states specifically in mind and certain ones that we definitely avoid just based on what the statutes are.
Right, exactly. So, this charging order protection, and it's just to kind of bring that to a close. We aren't trying to protect bad actors from the consequences of their own actions. We're not talking about secured creditors at all. We're talking about unsecured claims and providing a check and balance system to protect their businesses from unnecessary interruption or intervention. They still, as individuals, even if the creditor can't get their interest in that company, they still can get all their other assets. It's not like they're foreclosed from other remedies. Right? So, but the charging order particularly will protect the business itself. And so the other thing, kind of in closing, if you want to think about it, and one of the things we need to put up are statistics. How many individuals are employed by closely held businesses, because the statistics say the majority of people are employed by these smaller businesses, not all the big corporations. So if you're an employee, right, this is good for you. Because, if you have a business owner who comes under, all of a sudden a plaintiff's group wants to attack that business owner, the last thing that we want culturally or, from a socioeconomic standpoint is all those employees to be impacted by that liability.
Yeah. Or the boss gets a divorce and all of a sudden you're out of a job.
Yeah.
Because somebody had to sell the assets to satisfy judgment or something like that. I mean, let's just pretend for a second that Amazon is a private corporation. Right.
Let's pretend.
Well, obviously it's not. But and Jeff Bezos gets a divorce from his wife.
Yeah.
They have to split the company in half. If she had the authority to just go start selling trucks and start selling warehouses and start selling all the IP, everything that Amazon has, think of what a huge economic impact that would have.
Right.
So it's that happening on a very much smaller scale, where it's like, how much disturbance are we going to allow the creditor to have with regards to collecting what they're owed?
Exactly.
And rightfully owed, but nonetheless, how that plays out makes a huge difference for the economy in general. And so that's why we like the charging order protection.
Right, generally speaking.
Yeah.
And in future podcasts, we're going to talk about specifically the way we want entrepreneurs to organize those businesses, because there are, other things to think about, because not only is there the third-party creditor issue, but, you can have an operational problem inside one of your operational modalities, or you have different types of businesses, right? You have a lighting business, and you do electrical, you do installation of large poles, et cetera. So you can have different types of businesses.
Right.
So in a future podcast, Kev, let's talk about how we actually structure those things and the importance of treating those things as corporations and companies and entities, and not as your own pocketbook. Because the reality is, if you're a small business owner, it has to be a business.
Right.
So you can't pretend that that your personal money is actually the business, because
a lot of business owners are just thinking, well, I'm paying taxes on all of it, and it's all coming up to me because they're all disregarded entities or whatever the case may be.
Right.
But they're not thinking about it in terms of the risk profile of each little business that they've set up, and the fact that if you do that all in one pool, it's kind of assess the risk. But we can talk about that at a later podcast. But if you're a business owner and you're thinking, man, am I in the right jurisdiction? Do I have charging order protection? Do I need to move? et cetera, et cetera. This is one of the things that we do for our clients is we assess the risk of their entire structure, and we give them a recommendation and show them what they should probably do moving forward to kind of deal with some of these creditor risks and make sure their companies are protected. So if you're interested in doing that, we aren't really taking a lot of clients right now because we're extremely busy, but nonetheless, we would love to talk to you and see if it would be a good fit for you. You can email me. My podcast email is kreddington@Pride Dairy Podcast. Elizabeth, I think yours is eMorgan.
I think it
right?
is eMorgan.
eMorgan @Pride Dairy Podcast. Those are our podcast emails, but you can also just go to our website, Elizabeth Morgan and Associates. Just Google that, and the website will come up. And we'll put a link in the description of this video and on this podcast, and you can just follow that. And then really quickly, in each of our podcasts, we like to talk a little bit about a partnership we have with our friends at Hargrove Firm. If you're looking for an estate plan that is not necessarily motivated by taxes, in other words, if you're not looking to make generational decisions and maximize for estate tax planning, that kind of a thing, that's kind of what we do. If you're looking for something that's just not necessarily motivated by taxes, we work with the Hargrove Firm. They're absolutely fantastic, have the smoothest process possible. It's not just a plug and chug estate planning kind of service. It's actually you're working with real lawyers in the jurisdiction in the state that you're at.
Yeah.
It's a fantastic service. So there's going to be a link down below if you're interested in that. Just follow that link, and that'll get you set up for the basic estate planning stuff. So charging order protection, got that one under the belt. And we'll see you guys next time to talk a little bit about the structuring. So thanks for listening.
Thanks so much. Have a great day.
All right.
Bye.